Good evening and welcome to Face to Face for the Newsfirst team. I'm Niresh. The remanding of a lady lawyer in Putlam a few days ago for contempt of court sent shockwaves through the legal fraternity, and it took the intervention of the Bar Association of Sri Lanka and the Court of Appeal, sitting on a holiday no less, to free her from remand. And of course we will follow the developments to see what happens of this particular action. But what this did was it laid bare the situation within our court system. If a lady lawyer can be remanded like this, and it takes the Bar Association and the Court of Appeal to sort it out, what chance do ordinary citizens have? What is wrong with our court system that this sort of thing could happen? Maybe it's the correct procedure, but the manner in which the BSL reacted quickly tells us that there is something wrong, and so we need to figure it out, and we need to bring in reforms to our judiciary. And to discuss all this, we have with us this evening Maithri Gunaratne, President's Counsel and former governor of 2 provinces. Welcome, Maithri.
Thank you very much, Niresh.
Right, Maithri.
You have brought me to a very dangerous program, I must say, today.
Well,
because
Maithri,
I don't know who is going to get angry, or whether everyone is going to get angry with me today.
Well, the situation is, Maithri, that the common man and woman in this country goes through this every day.
Correct.
Go to a courtroom. We all dread going to court.
Perfectly correct.
Because it's such a the image which comes up when you say Naduak, a case, magistrates court, district court, high court. The image is one of, oh my God, horror. We're going to waste our time. We're going to have to go in there and
but we don't know what's going to happen.
We don't know what's going to happen. We don't know even if the case will be taken up today. And so many, witnesses have to come. If they don't come, they'll be put behind bars, possibly. So it's a huge waste of time, and it is such an inhuman experience. Of course, not all courtrooms in the country are like this. Not all judges, are harsh in their treatment of the people. You get some very fine judges. You get some courtrooms which are friendlier than others. But by and large, it is not a pleasant experience. And I'm not even talking about whether you are a criminal or not. This is for the ordinary person. So people avoid going to court as much as possible. So what do we do about this, Maithri?
Niresh, let me say first that there is a breakdown in all standards, be it the legal profession, the medical profession, every profession. There is a breakdown of all standards. So with that comes all these unforeseen problems. Now, this judge in Putlam is a judge I have appeared before. She has been extremely courteous, and I have watched, because I go for trials. I'm doing the Easter bomb. There are 2 trials I'm doing in Putlam. I have gone for that case, and generally, when you say Easter bomb and all that, there is like a slight prejudice, right? But I must say, this lady, there wasn't an iota of prejudice, and she works on time. She's according to what I know, she's an excellent judge. She's an excellent judge.
But it's not about the judge.
No, it's not about the judge. No. So what I'm saying is, because now her actions have been, they are finding fault with her actions. No, Niresh, that's my issue.
But we'll let the Court of Appeal decide
that. Yeah, so therefore, what I feel is, sometimes, Niresh, now the generation Z, so they say, now it's their generation, and I don't know whether they would conform to decorum, respect and things like that. So, I feel it is a culmination of various factors that led this lady to do this. Of course, it is excessive. It's excessive. It is
that seems to be what the Bar Association is saying.
It is excessive, and it is a deterrent to the right to representation. Right to representation. So I hope that this incident will shock the conscience of the legal system, and they will wake up to put in the correct checks and balances in every section of the legal profession. I feel that judges need also to be trained more, and the training should happen maybe once a year. And I feel the lawyers maybe at law college, it's not only just passing an exam, Niresh. You need to. There are a lot of ethics. There are a lot of customs. There are a lot of traditions which are prevalent in the legal system. Those are not written. Those are not written. So therefore, you need to put these youngsters through those phases. Otherwise, what is going to happen is this type of thing is going to be more recurrent. And the moment this happened, I must say, the president of the Bar Association, Mr. Rajiv Amarasuriya, he acted very swiftly, and as the president of the Bar Association, representing the lawyers of this country, I would say he acted extremely well, and I think he was just inducted, and it was it was a fresh operation for him. He spoke to the Court of Appeal, President of the Court of Appeal, and made a request that they come even on a holiday to show. He demonstrated that he is a leader who will stand with the bar. Now there is another school of thought. How can they have this on a public holiday? That all depends. That it all depends on the need. And the other thing is, Niresh, our constitution, according to our constitution, the sovereignty is in the people. It is not in the king or the president. The people are kings. It is the people's sovereignty that the people give the president as the executive, to the parliament by voting at the parliament election, and through parliament they exercise judicial powers. So the powers of the people, judicial powers of the people, are exercised through parliament on behalf of the people. So therefore, Niresh, all courts, all structures of government have to be in favor of the citizen, because the citizen is sovereign. So therefore, whether it is a Saturday or a Sunday or a Monday or a holiday, if the citizen is at peril, then what is needed is the court system must come to save the citizen.
Absolutely.
Right. And other thing is, Niresh, now, in our law, there is a presumption of innocence. That is, we'll say, now, a judge sitting in a court is constitutionally, there has to be a bias, is constitutionally biased. When he sees an accused before him in a magistrate's court, in a criminal court, he has to look at the accused as a person who is innocent. But unfortunately in this country, I must say that they are looked as if they're guilty. So these mindsets must be changed, and the judges must realize that they are exercising people's power on behalf of the people, for the betterment of the people. So therefore, they can't take the law to their hands. They can't take the law to their hands. If they take the law to their hands, then this is the repercussion. So, Mr. Rajiv Amarasuriya, the Bar Association, has stood up for the moment and taken care of the lawyer, and we will see what happens thereafter. But I am told, Niresh, that I am being fair to everyone. I have been made to understand that even this lady lawyer has been a bit indifferent to court. Now, there is a certain decorum when you go to court. You have to bow. You have to, addressing the court is done in a certain manner.
Now, let's leave that for the Court of Appeal and so on.
Okay.
Right. But now you're talking about a lawyer, who should know decorum, right? But what if it's an ordinary citizen? We are talking some farmer from Munragala. He appears in court. He doesn't know, even though he's told by his lawyer, or maybe his lawyer forgets to tell him that he needs to bow, right? Then he walks in. He's never been to court before.
In fairness, Niresh, now I remember there was an instance where a poor farmer had come to court, and his shirt didn't have about 3 buttons. It didn't have about 3 buttons. So the judge who had seen this has been very harsh on this guy. And somehow this had gone to the then Chief Justice, Mr. Chief Justice Sarat Silva. And in one of the discussions or seminars with the judges, they have said, he has very correctly said that, you can't do this. You can't. They are the citizens of this country, and when you're sitting as a judge in a rural area, sometimes some people don't have even a shirt, and they wear a shirt and come because they want to respect the court, but they may not have buttons. So don't go to that extent. So what I'm saying is, Niresh, now this knowledge has to be passed to these new judges. This education process must take place.
It's common sense as well, isn't it?
But the point is, common sense is the most rarest qualities you get in society today. If everyone had the common sense you seem to think people have, I don't think we would have been in this mess, Dhiresh.
Well, everyone doesn't, but certainly the judges should have, and the lawyers should have.
Judges also cross-section of society. So there is a cross-section of society. So what I'm saying is, there has to be constant. Now you take the medical profession. Niresh, there is constant training. They are bringing in new knowledge. They are bringing in new techniques. They are giving new systems. So I feel, even in the legal profession, I hope Mr. Amarasuriya realizes this and he starts doing this. And another important thing is, now this has opened the doors. This instance where you very correctly pointed out that on a public holiday, how did they do this? Now this instance has opened the doors for the citizen, and on behalf of the citizen, citizen's power is the power which these courts are dispensing. So on behalf of the citizen, whether it is a Saturday, Sunday, Monday, or irrespective of the day, if the citizen's rights are at peril, if the Court of Appeal or any court is notified that there is an issue like this, that court must sit immediately.
Absolutely.
That court must sit immediately. So this is a superb opportunity where I think Justice Lafa, the President of the Court of Appeal, has acted as a true judge of the people. This should not only be to the Bar Association or these elite bodies, but if a citizen is at peril, if a citizen's right is at peril, for instance, if someone is going to be arrested, or if there's a habeas corpus where you need to find where the body is, so then now you have to make a mechanism. You have to make the mechanism where you can alert the Court of Appeal, alert the High Court, alert the magistrate at whatever the time, and get their case called, and citizens' right needs to be protected.
Now, our legal system is not user-friendly. Maithri, we know this. It's all about, oh, this is the weekend, or that judge is not there. You know, it's a bureaucracy in itself. And people fall victims to this system. We have seen innocent people being arrested on, you know, when it's a long weekend is about to start, and then you can't find the magistrate. Things like this happen.
No, Niresh.
So now, you know, what this particular incident, this case has, you know, thrown the limelight on is we need to have, you know, to have a level playing field for all citizens.
I agree with you totally. Now, when now there is Mr. Professor G.L.P. Rees, when he was the Minister of Justice, he brought in this anticipatory bail provision to the Bail Act for the simple reason that political opponents were hounded out and arrested on a Friday and remanded. So, in 1997, if I recollect, the Anticipatory Bail Act was brought in, where, Niresh, if we'll say you're going to be arrested for a non-bailable offence, you can notify the OIC of the police station, go before the magistrate by way of an affidavit and a petition, and inform the magistrate that I'm going to be arrested. Magistrate has to immediately send notices to the OIC of the respective police station. The bail application has to be called within 7 days, and the judge must make a decision. Granting of bail is the rule. Granting of bail is the rule. Non-granting of bail is the exception. Whereas previously, before this act came into operation, granting of bail was the exception, remanding was the rule. But I am sorry to say that still remanding seems to be the rule and granting bail seems to be the exception. So now I have had few nasty instances where on behalf of the citizen I have invoked the provisions of the anticipatory bail law on non-bailable offences, but the judges don't grant bail. So what do? They have allowed the police to come and take and do anything against me. So now these are instances where the judiciary, the judicial system needs to address, because Niresh, going to courts is a very expensive exercise. Lawyers are expensive, procedures are expensive, documentation is expensive. So therefore, it is time, with this Putlam incident, it is time for the whole legal system to sit down and rethink the strategy and make a system which is friendly to the citizen.
Now, I agree wholeheartedly, but Maithri, when you say the system, well, who is going to sit down and do this?
From the Chief Justice downwards. The Chief Justice, the Court of Appeal, the High Courts, the Magistrates Courts, the District Courts. And the other thing is, Niresh, I have always, the judges whom I have met, I speak to, I always say, now we'll say in a district court, there will be one or two issues, Niresh. One or two issues. I have seen some judges. I will tell you a very good example. I was appearing for a client of mine in the Nigambo Magistrates Court recently. Nigambo Magistrates Court, and I made the application. This was a PHI, Public Health Inspector. My client is an exporter of crab meat and fish to abroad. So the public health officer must have asked for some help, and since that was not forthcoming, he had given an adverse report and filed action against this guy. So I went before the learned magistrate and I informed the learned magistrate, lady magistrate again, and I said, Madam, my client is exporting $12 million worth of fresh fish and crab and prawn to the US. I have a USA approval, the Federal Food Bureau or whatever approval. The problem I'm having is now the PHI is not giving it to me because they expected something from me and it was not forthcoming. What did she do? She said no. The exporter also must survive and the citizen also must be protected, because exporter can't, because he's exporting, he can't pollute the environment. So therefore, you have to give me a fresh report. You have to give me a fresh report within 2 weeks whether this exporter is, whether this is true. 2 weeks when fresh report came, there was no pollution. So now that is what I'm saying, the issue. There is only 1 or 2 issues. So this lady magistrate saw through the whole thing, picked up the issue, dealt with it immediately. Case will be, I feel they have to withdraw the case if there is no evidence. So if every magistrate, every judge takes a little time, takes a little pain in going into the issue and seeing whether this can be resolved, then Nilesh, my humble submission is it can be done. And Nilesh, now for instance, there are cases, partition cases, which are going 3 generations.
Absolutely.
3 generations. 1960 they have started. Can you imagine 50, 60 years? The partition cases are going on. Now all this, sometimes some partition cases, Nilesh, they get even less than a purge. Less than a purge. So, but no one sits down, looks at the pedigree and sees how many contestants are in this, how many parties are in this, and what is their share. So once you size that up, and if a judge tells a litigant, look here, you have only, at the best, you have only 1 purge. So with your 1 purge, there is nothing much you can do. So why don't you consider in selling it off or doing something like that, or amalgamating with someone else and bring about a settlement, see that the parties are reduced and bring an end to this matter. So if this approach is taken, Nilesh, I would say that most of our cases can be amicably settled within 6 months to 1 year at the most.
Interesting thought indeed, Maithri, and we'll delve into this a bit further, but first we'll take a short commercial break and we'll be back with Maithri Gunaratne PC.
ඔබේ ගමේ නගරේ දේශපාලනයේ හෙට දවස සතිය දිනවල සවස් 6:00ට
Welcome back to Face to Face. We are with Maithri Gunaratne PC. Maithri, now there are, as I understand it, about 1 million cases before court, something like that.
Maybe.
I saw that one of the ministers had said it recently. Now this is ridiculous. And like you said, some cases are from the 1960s, 1970s. Clearly quite ridiculous. I mean, I suppose there are other countries where this does happen, but certainly it doesn't happen in countries which we consider to be advanced societies rather. Right. Now, how do we sort this out? And here I think it's cultural as well. Sri Lankans love to quarrel, love to fight. They don't like to say that mea culpa, I'm wrong, it's my fault, I'm sorry. They don't like to say that. You will find, every day on the street, if you drive, you will find 2 vehicles. One has been hit by the other from behind. So clearly, it is the fault of the driver behind. But he will get down, he will scream at the other guy, insult him, insult his family members, and then say that I am so and so, my brother-in-law is so and so, and get on the phone in the middle of
were you
the
a
street.
victim or were you abused?
No, we see this all the time. And it's laughable. It's absolutely laughable. When I get into a fender bender, if it's my fault, I just get down and say, my fault, sorry, we'll move it to the side and let's talk about it. And I take some pictures or a video with my phone, take it off the road. But our people love to block the traffic, right? And this gives them the power somehow. I've had an accident. Of course, it's just a scratch, but somebody has bumped my car or I bumped somebody's car, and that gives me the authority. Forget the sovereignty of the rest of the people and their right to travel, but yes, I will block traffic on Gaul Road, Dali Road, Union Place, you name it, High Level Road, doesn't matter. Rush hour does not matter. And then they absolutely have to wait until the insurance guy shows up, which could be 10 minutes, 15
Maybe
minutes.
one
more. Or the traffic police shows up. That also could take a few minutes. So meanwhile, an almighty traffic jam. So my point here is, we don't like to negotiate and say, okay, I'll pay for your damage. Then let's move it to the side. I'll call my insurance guy, because in the end, that is what happens. The traffic policeman shows up, the insurance guy shows up, and the traffic policeman, who doesn't want to be writing statements and taking this to court, he says,
that at the back of your hand,
can you talk and sort this out? And so in the end, that's what happens. We know it. We know it. But this societal issue, and that's why I think now you were talking about, 3 generations fighting over one perch.
On a land.
Yeah, on a land.
And that person, some have not even a perch.
Yeah. So, I mean, what's the issue here? This absolute craziness, obstinacy. They don't want to sit down and sort it out. But how do we change this?
Now
how do we get this?
Superb question, Nilesh.
The culture of resolving, negotiating.
Now, you said that there are about 1 million cases. Okay. Out of this million, I would say 40 to 50% are traffic cases, traffic offences, speeding, parking at the wrong place, not wearing the seat belt, things like that. Now, all these offences, you can give a ticket, spot fine.
Absolutely, yes.
Okay. Now, a spot fine also, if you are giving a spot fine, you might as well empower the policeman who has apprehended that wrongdoer to give the spot fine, collect the money, and deal is done.
Well, with digitalization, you don't even have to hand over the money. I mean, it could be deducted out of your bank account.
Bank account. So why aren't we making use of technology? Now the president has got down Dr. Hans Vijay Surya.
Very fine gentleman.
We used to travel to school in the same bus. Right? So now for Hans, this is going to be, easy as falling off a log.
Child's play.
Child's play. So, I mean, you bring that into operation, Nilesh, you sort out most of your cases. Then the court has the time to go into the fatal accident cases. And every day it is speeding, drunken driving. If you get caught drunk driving, if the balloon turns green or whatever the color, then the fine is 25,000 bucks. And there is a discretion with regard to the license, 1 month to about 3 months suspension. So you might as well have a system where you pay the fine of 25,000 rupees because the balloon, the indicator has turned green, and or if there is no balloon, you send him to the JMO and the JMO says that he was under the influence of liquor. Case done. So you don't need to send that to court and take that person. Just imagine, Nilesh, he will say, if you, I don't hope that it will happen to you, but if you get caught drunk driving and you have to go to a magistrate, you have to go to the police. Police will keep you till the next day. Then thereafter you are told to come to the magistrate's court. You have to go to the magistrate's court. There are 500, 600 cases. So your whole day is gone. Whole day is gone. And you may be a person who is doing so much of productivity for the economy. So how much money, how much time we are wasting?
Absolutely.
So these are factors, Niresh. These are factors where my very good friend Mr. Harshana Nanayakara will have to think and will have to implement as fast as possible. That is with regard to bulk of the traffic cases. Then there is the other set of cases which are the drug-related cases. Now, these drug-related cases, Niresh, the problem is the government analyst report takes a month of Sundays. So I can't understand why we can't make a system. Why can't we decentralize the government analyst department to all the provinces? We are talking of decentralization of this, that, everything, sharing of power and all that. You have different officers of the government analyst department, different officers of the attorney general's department, and they will be able to, when you are producing a suspect for drugs or we'll say anything like that, you go get the government analyst report and produce them. Then what happens is the magistrate will see whether this is within the permitted limits, either grant bail or he finishes the case, then the case is done. Now what happens is, he is arrested. Most of the time we'll say it is heroin or whatever the drug. Most of the time it is either Panadol or it is either something else, some other substance when the report comes out. So that guy has been in remand for 6 months, 1 year, 1.5 years. When the report comes, the quantities are down. So therefore the magistrate can grant bail. So these are very practical ways, Niresh, to sort it out. Then there is another set of cases. Now the police does another thing. The police, for the slightest thing, they say, we need to get Attorney General's advice.
Yes, that is a very, very irritating phrase that we as journalists, we see this all the time. The police are asking
Attorney General's advice. And no, the Criminal Procedure Code doesn't have a provision for a magistrate to refer the matter to the Attorney General for his advice. No. Police can consult the Attorney General if it is a complex issue. But what happens in fact, Niresh, the police are prompted by either political or financial reasons to take action against people. They arrest them, they produce them, they remand them, and then they know that there is no evidence. So the only way they can shelve the case or put it under cold storage is by coming and telling the magistrate that it is going to the Attorney General's department.
And of course, that will take weeks or months.
No, years.
Yeah. Years. Just to find, they can't find the Attorney General.
For years.
Yeah.
So therefore, Niresh, we are not making use of the provisions of the law, because now a magistrate under the Criminal Procedure Code, if there is a person taken into custody, within 14 days, the police have to file a report before the magistrate under 120 subsection 3 as to what evidence there is against the suspect. A synopsis or a summary of the evidence against the suspect. So, moment that report is filed, the magistrate is having been trained, or a trained person will see whether that evidence will suffice to make him guilty for a criminal offence. So, if there is no evidence, the magistrate can say, I will discharge him for the moment, and if there is more evidence which will come, we will reconsider in opening the case. So, these are ways, Niresh, you can bring the backlog of cases to, you said 1 million, you can bring it to about 200,000 or 300 or even less than that.
Now, Maithri, another key question here. You go to court. Today is the date, you're told, come to court, witnesses have to come, everybody's there, but some technical reason, or the magistrate, the judge has too many cases that day and it gets postponed. There are umpteen reasons, this.
Yes.
Everybody's time has been wasted. But the date given is not tomorrow,
No.
not next week, 3 months, 4 months, 6 months down the road.
Now, Niresh, if you take our Supreme Court, right,
Which is a lot more efficient than the magistrates and so on.
The fact of the matter is that the Supreme Court, you're lucky if a case is taken up twice a year. Then the Court of Appeal is faster. Actually, the Magistrates Court, they within every 2 months cases are called. District Court sometimes takes 6 to 8 months to give the next date.
Yes.
So
what's the problem?
No. So that's what I'm trying to address it. So there must be a law, or the judges must be given instructions that a case cannot be postponed for more than 2 months at a time. So at least, Niresh, during 1 year, the case will be heard 6 times. And in fairness to the litigant and the lawyers, judges always give dates which are suitable for the lawyer. And most of the time they are asked, are you free? Will you be coming? And some judges, which I think every judge should do, they will say, Mr. Gunaratne, if you are not coming, I am not going to give you a date because of anything else. Your junior will have to do the case. So, moment the judge is a bit firm and a bit stern, things will fall into place. It is, I mean, there can be a problem, Niresh. A lawyer can have a problem, a litigant can have a problem, that can intervene. But all that, the judge has the discretion to see whether this is a habitual person who is getting dates and delaying the case. And if that is so, he can put his foot down and say, no, nothing doing, case is going to be taken up. I have seen that happening in many cases. And moment the judge is firm and stern, things automatically fall into place.
Excellent thoughts indeed, Maithri. But I'm afraid we are a little pressed for time this evening. One just hopes and prays that the learned judges and the excellent lawyers of this country will get together and sort out these matters, because it's certainly within their ability and their experience to do so. And it will, of course, strengthen the sovereignty of the people. My thanks to Maithri Gunaratne, President's Counsel.
It has been a pleasure being with you.
Thank you for being with us and enlightening us on these matters. And thank you to you at home for watching. Don't go away because the news is coming up next. Have a great evening.